Hi everyone. So in this particular section of video, we will be dealing with section 73 of the Indian Contract Act, and I'll also discuss about the remedies that you can get after the breach of contract in two ways. The first is the compensation as under section 70, and the second is the remedies as a specific performance. So specific performance of a contract is very important in today's period of a time. After 2018, the government has brought some kind of amendment with respect to that, and after that we see that there are certain things that have changed in the specific relief act of 1963. Some wordings have changed, like that there was may, but now it has been converted into the shell. And when then it is converted into the shell, it means that court doesn't have any discretion, so court has to grant a specific relief on the basis of that. Now, not going too much detail with respect to the specific relief act, I'll be more focusing today upon the compensation as a remedy that we can get under the Indian Contract Act 1872 section 3. We will be dealing the compensation for loss or damage caused by the breach of contract. So what we can get, the compensation for loss or damages that is caused by the breach of contract. When a contract has broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract. So this is a simple thing. The contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of the things from such breach, or which the party knew when they made the contract to be likely to result from such from the breach of it. Now here it is saying that if a contract, when the contract has broken, the party who suffers is entitled to receive from the party who has actually breached that particularly the contract. So he will receive, he is entitled to receive the compensation. The party who is suffering, the sufferer party, is entitled to receive an compensation under the this breach of a contract. Now the second thing that we can understand here is such compensation is not to be given for any remote or indirect loss or damage sustained by reason of such compensation. Okay, so compensation will be given only for the direct losses, not for indirect losses basically. Now the second thing in this section 73, which talks about the compensation for failure to discharge obligation resembling those created by a contract. So now the second point is some kind of a very tough point that people find difficulty to understand this particularly. Section 73, the para second, we'll be more focusing upon this, and I'll be reading it. Just please look at one, the contract act. When an obligation resembling those created by the contract, when an obligation resembling those created by the contract has incurred and has not been discharged. Now it has been not been discharged. Any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default as such person has contracted to discharge it and had broken his contract. So now here there is a resemblance of a contract. I'll give you an example, not go with respect to this particular wordings. I'll give you an example to understand this much better. I am a person A. I have given some good or services to the party B. Now on the other side, that party B is not performing his contractual obligations. It's not an formal contract. First we need to understand, it's not an formal contract. It's an thing that is seen, that it's an created, it's just like a seems, not it is an contract. It's not a formal contract that has been written on paper or anything. It is just resembling that it is a contract. Okay, because I have given some kind of goods and services to the party B. Now party B, what in the return of party B I'll get some money amount. Okay, but the party B is not showing an interest to repay me back that particular amount, that the services and the amount services and the goods that I have given to party B. Now here I will be sufferer. Okay, I will suffer, and then I'll approach to court and file a suit against party B for an compensation, for demanding an compensation. Now the concept here is, we'll be dealing with the concept, refers to the situations where one party must compensate. So one party must compensate another for not fulfilling an obligation. Okay, so that party B hasn't fulfilled an obligation that is not technically based on a contract. So there was a no contract, it was just resembling like a contract it was. Okay, सो अगर मैं आपको हिंदी लेम टर्म्स में समझाने की कोशिश करूं इसको बेटरली, तो हम ये बोलेंगे कि जो मैंने कॉन्ट्रैक्ट यहाँ पे जो मैं कर रहा हूँ उसके साथ, वो कोई कॉन्ट्रैक्ट नहीं है, वो हमने कोई राइट रिटर्न में या फिर फॉर्मल अपना हमने डॉक्यूमेंट डॉक्यूमेंटेशन वर्क नहीं करा है, बट हमने क्या करा है उसकी जगह पे, we have actually it seems that we have done a contract. Okay, it's resembles, because I have given some goods and services to the party B, and party B is not fulfilling its obligations to repay me that particularly amount, है ना. But the court will see here that I have done something, है ना, for the party B. So instead of not fulfilling in his obligation, the party B will be compelled to give me the compensation back, ओके, इन द फॉर्म ऑफ डैमेजेस. तो ये चीज समझ आया कि भाई हमारे बीच में कोई कॉन्ट्रैक्ट नहीं हुआ है, बस मैं ये चाहता हूं कि भाई जो मैंने उसको गुड्स एंड सर्विसेज प्रोवाइड करी है उसके बदले मुझे दे दे, ठीक है. तो बस मैं इसी वजह से जो है कोर्ट पे जाऊंगा. इतना समझ आया. दिस इज एक्चुअली समथिंग वी कैन से देयर इज अ रिजेम्बलेंस ऑफ अ कॉन्ट्रैक्ट. देयर इज नो पर्टिकुलरली कॉन्ट्रैक्ट, देयर इज नो फॉर्म ऑफ कॉन्ट्रैक्ट. दिस प्रिंसिपल इज ऑफन फाउंड इन क्वासी कॉन्ट्रैक्ट्स, बिकॉज दिस इज काइंड ऑफ क्वासी कॉन्ट्रैक्ट्स which we can see, or the situations where the law imposes an obligation to prevent unjust enrichment or loss. So the party B is getting an unjust enrichment, okay, he is getting some benefits. Now I am in loss, the party B is getting unjust benefit, unjust enrichment, and I am in loss. So what will happen? The court will say to the party B, court will compel party B that please repay the amount or repay the same thing that you have taken from party A, है ना. So these two things can be created before the court of law. We need to understand. Now there are some key aspects that we can deal with respect to this. Is first, there was no formal contract. I told you that there was no formal contract between the parties, but the one party has acted in such a way that creates an obligation. I acted in such a way that it has created obligation for party B to fulfill its obligations. There is a legal obligation, there was no actual contract, and now the party B has to pay some compensation instead of that, okay. Now here the case law we will go with one of the very important, Puran Lal Shah versus State of Uttar Pradesh, 1971. This is the case which talks about the merit quantum merit, sorry, ठीक है. तो quantum merit means that as well as I deserve, or we would say that as much as I deserved, मैं जितना डिजर्व करता हूँ वो चीज़ मुझे मिलना चाहिए, या तो सेम मिले या तो कॉम्पनसेशनली मुझे वो क्लेम वापस दिलाया जाए, ठीक है. सो दीज टू थिंग्स टॉक्स अबाउट दीज टू थिंग्स कम्स अंडर द एम्बिट ऑफ बेसिकली द क्वांटम मैरिटम. नाउ द पुरन लाल शाह वर्सेस स्टेट ऑफ उत्तर प्रदेश 1971 case law talks about the facts we will be dealing. First of all, the government took possession of a land without a formal agreement with the owner. The owner demands compensation. Now what happens here? The state of Uttar Pradesh has taken the possession of a land from the owner, okay. Owner, we need to understand, the owner is the title of the owner, has a title of a land, okay, and you cannot directly take that particularly land. And one thing we need to keep in mind, that government is also the party to the contract. We can the contract law will judge a government as to the party of the contract, okay. And government here cannot take that particularly possession of a land without a formal agreement or without giving some kind of compensation to Puran Lal Shah. But the government has taken the possession of land, so the infringement of the possessory right of the Puran Lal Shah, actually the owner demands the compensation here. The Puran Lal Shah is saying that I want compensation, or I want my back land to me. So now the court decision came, and the court's decision, the Supreme Court's decision came. The court held that even there was no formal contract, the government bound to compensate the owner. Government is bound to compensate the owner. मतलब कि भाई जो गवर्नमेंट है उसको ये पैसा देना पड़ेगा, ठीक है. वो मतलब कि कॉम्पनसेशन उसको देना पड़ेगा जो वो क्लेम कर रहा है ओनर, ठीक है, अंडर द क्वाजी कॉन्ट्रेक्चुअल ऑब्लिगेशंस, बिकॉज taking possession creates an obligation, है ना. And taking an possession creates an obligation on the behalf of government. So government has to pay that back to the that compensation as back to the Puran Lal Shah. Now the significance of this particularly case law is that it reinforced the idea that obligations resembling contracts can lead to the compensation. So there was no particularly actual contract, okay, there was no written contract, just government came and take that particularly possession of a land from the owner Puran Lal Shah, and now it is just resembling that it is just a resemblance of a contract that the compensation will be given to the Puran Lal Shah back. So here is only just kind of a resemblance of a contract, okay? There was no actual contract. Now the second important case that we will be dealing today is the Satyabrata Ghosh versus Mugni Ram Bangur and Company Limited. So 1954 case it is. The facts of the case we will be dealing in more detailed way. But firstly, a builder failed to deliver plots of a land after receiving an advance payments. The agreement was not finalized into a formal contract. So what is actually happening here? A builder and a builder says that I will deliver a plot of a land to you, but due to and the person who was taking that particular land has also paid advance payments to the builder, has given an advance payments to the builder. The agreement was not finalized into a formal contract, but there was an agreement that was not finalized into a formal agreement. Okay. The decision of the court came. The Supreme Court held that even without a formal contract, there was no formal contract. There was just an obligation that that particularly man Satyabrata Ghosh has given a payment in an advance, given an advance payment. Okay, but he didn't done a agreement in a formal way with the Mungni Ram company limited, Mungni Ram Bangur company limited. Okay, whatever the company is. तो उसके साथ उसने जो है कि एक रिटर्न में अपना एग्रीमेंट नहीं करा, लेकिन वो रिजेंबल करता ये है कि भाई उसने जो पेमेंट करा है बेसिकली फॉर द पेमेंट दैट ही हैज डन टू द company, basically it resembles that it is an formal, it's an contract. Okay, it's an resembling contract. So now the company's obligation, the legal obligation of the company is to repay the to give the land to the Satyavrata Ghosh. ठीक है. So the builder's failure to act on the obligation required compensation. So here builder won't able to do its contractual obligation, didn't fulfill this contractual obligations. Okay, and as there was no contract, there was no actual contract, but it was just resembling that it was a contract because Satyabrata Ghosh has given advance payment to that particular company. Now the significance of this particularly case is that the case demonstrated the application of quasi contractual obligations in the real estate transactions. So it is a case of a real estate transaction, and resembling of this advance payment given to the company shows that a contractual obligation has been arise in the behalf of, on the behalf of that company, and company is liable to give the land back or to repay the amount back with the compensation. So we have to understand the whole scenario, that how much important the case is all about. Thank you for listening this particular concepts with respect to the breach of contract, that remedy you can get with respect to the damages. We'll be dealing with some another case in the next video. And Satyavrata Ghosh versus Mugni Ram Company Limited, I'll be dealing in very detail. Thank you for listening and thank you for watching.